Good evening and welcome to this Macomb Township Zoning Board of Appeals meeting. Today is the 2nd of September. The time is 6:30 and my name is Aaron Tuckfield. I'm the chairman of the Zoning Board of Appeals. I'm calling the meeting to order. That is the first item on tonight's agenda, and the second item is the Pledge of Allegiance. If you could stand with me for the pledge. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, that takes us on to item 3, which is roll call. Ms. Lawson, will you call the roll?
Yes, sir. Member DeCoster?
Present.
Chairman Tuckfield?
Here.
Member Slauson is here. Member Piper, Member Piper and Member Posey are absent.
Very good, and I don't believe the ZBA bylaws require us to note excused or not excused, although they did properly notify us and let us know ahead of time that they would not be here, so we appreciate that. And since our quorum is 3, we do have a quorum this evening. One thing I'll mention, I believe we have one item on the agenda tonight. Because we are a 5-member board, we only have 3 here tonight. We still are required to pass any motion by a majority vote of the board. So any motion that we make in order to affirmatively pass will require all 3 of our votes this evening. One thing that's typical for us is at the point that we're going to go to a vote, I will make sure that I ask you guys if you wish to have us proceed with the vote or if you would wish us to table it to a future meeting. Since we're short on members, that's usually a courtesy we provide because of that. So, and I can explain that to you as we get into that if you have any questions on that for clarification. All right, and actually before we go further, I'd like to entertain a motion to not call Member Posey or Member Piper on any roll call votes this evening.
So do, Mr. Chairman.
Motion by Ms. Lawson. Is there support?
I'll second that.
Support by Mr. Coster. All those in favor, please signify by saying aye.
Aye.
All those opposed by saying nay. That motion carries. Next is item 4. This is where we will look to address any conflict of interest. Ms. Slauson will call the roll, and if any members have any conflicts of interest on items tonight, please say yes. If you do not, please say no when your name is called. Ms. Slauson, please call the roll.
Okay. Member DeCoster?
No.
Chairman Tuckfield?
No.
And Member Slauson? No.
Very good. With that, we're going to move on to item 5, which is the approval of the agenda this evening. I believe we have one item, 7A, on the agenda that the applicant has requested to be withdrawn. So I would entertain a motion for an amended agenda removing 7A from the agenda as presented.
So do, Mr. Chairman.
Motion by Ms. Lawson on the amended agenda. Is there support?
Support.
Mr. DeCoster. All those in favor, please signify by saying aye.
Aye.
All those opposed by saying nay. That motion passes and the amended agenda is adopted. Item 6 is approval of the previous meeting minutes. This will be for our August meeting. I know I have one change, but is there any other comments or changes on these minutes before I bring mine up? I just had one, and that is in the comments at the end of our meeting. I don't have the page in front of me, but I referred to Zoning Board of Appeals members. I would like to strike the word member. I believe the actual quote was, I think I said the board, and that was what I was referring to, and I was referring to the board as a whole, not individual members, and I think in this particular case it's an important clarification. So if there's no concerns with that, I would entertain a motion to approve the agenda with that change in it.
Motion to approve.
Motion by Ms. Slauson. Is there support?
I'll second that.
Thank you, Mr. DeCoster. I think we might be in a rhythm with that tonight. And just to clarify, Dawn, that is for the amended agenda?
Yes.
Okay, because if you want to do a motion for as read, I'd entertain that too, but just want to make sure I verify. All right. Motion by Ms. Lawson, supported by Mr. DeCoster, to approve the amended agenda. All those in favor, please signify by saying aye.
Aye.
All those opposed by saying nay. That motion carries. All right, old business is empty this evening after our amended agenda, and we are moving on to item 8, which is new business. This is a variance request from the zoning ordinance, section 10.0311 EF3, to allow an existing hot tub pool to be located 5 feet away from a side property line where 7½ feet is required. This is for permanent parcel 0806278.025. Patrick Kenny is the petitioner. Mr. Box, do you think you could give us the review from the department, please?
Yes, thank you, Mr. Chairman. And just for clarification, I think you received the updated sheet signed by Mr. Maples with regards, I think there's actually two separate variances, not one, that are needed. Both similar issues, setback from the same side yard, but there's actually two different ones. One is 5 feet and one is 2 feet, I believe.
Very good.
The property, as you mentioned, located south of 26 mile west of Romeo Plank. It's the Via Villaggio subdivision. You can see on the map behind you the location, and the neighboring property, I believe, is still vacant. I know this aerial is, I think, early 2020, but I think it is still vacant. So the question in hand, again, with regards to the setbacks, you can see on the screen behind you, there's actually two different ones. The hot tub is 5 feet when it's supposed to be 7.5, and the patio or deck area is 2 feet off the property line when it's supposed to be 7.5. So this did actually come in through the building department, and they were issued a building permit, it looks like in 2016. This is prior to me being here, but Mr. Maples explained it to me a little bit. So you can see on the left, the permit that was issued has a different layout. It doesn't include a hot tub or a fire pit area. And then on the right is what was actually constructed. And the markings in blue show kind of the setback areas that are in violation. Here's again some pictures just to show you how close it is to the property line. The fence you can see in the picture on the right is on the property line. So at this time, I guess our findings internally, I know Mr. Van Tiffelen in particular, the engineering and water and sewer had some concerns with the swale area. They typically would request at least 3.5 feet in order to allow drainage. I don't believe the building department had any specific issues with the request. I think from the planning perspective, it doesn't have any impact on public safety. We're just asking the applicant, which I believe they're here this evening, to talk us through the hardship that they see, because at this time, I don't see that staff really views where the hardship is. So with that, I think we're going to, if the applicant would like to speak and explain that.
Very good, thank you, Mr. Box. Mr. Box, and I do see the drawing here. I apologize for not having mentioned that in the agenda. Just a clarification, so are we considering this 2 variance requests, or are we considering a 1 at 2.5 feet that covers both? Because both of them are side yard setbacks. Do we treat the pool and the patio or the pool and the sidewalk differently?
I think you could treat them differently. If you said 2.5 or 2 feet, whatever, I think the 2 feet is the one that they're asking that was shorter. I think you could just say 2 feet for the whole side yard, or...
You could say 1 and not the other.
But they are technically 2 different elements in the building and the ordinance, the building code and the ordinance. So the hot tub is called out specifically. It requires 7.5 foot setback, and the patio area requires a 7.5 foot setback. So in that sense, they need 2 separate.
Very good. And then just to double check on that, Mr. Loya, are we able to consider a variance that maybe is needed but has not technically been requested? Is that something that's within our leeway here? Because obviously, I believe the variance requested was for the pool or the hot tub, which is further away than the sidewalk. Obviously, they need it. I just want to make sure we're within our bounds. We don't have to have the petitioner ask for something additional before we can consider it.
To clarify, they did ask for...
They did ask for
those.
both.
The updated one, I think you have, I don't have it in my pack here, but I'm pretty sure I put it in yours. The one that's actually signed by Mr. Maples at the bottom. There should be one that has like a yellow sticky note on it.
Yes.
But there's a separate one where Mr. Maples signed it, where it identifies the 2 different pieces of the ordinance.
I see. So we're considering the sticky note as representation that they
Yes.
did request. Okay, very good. Thank you, Mr. Loya. Sorry for not having grasped the situation properly here.
Always happy to help.
All right. Okay, very good. Thank you, Mr. Box. Any other questions for Mr. Box before we move on to the petitioner? Hearing none, if you can come forward, just go ahead and sit down here. State your name and address for the record and give any comments you might have.
Patrick Kenny, 16280 via Montella, Macomb, Michigan, 48042. So just to be clear, we did request both the variances.
Thank you.
And I guess we're here today at the mercy of the city or township. We hired a contractor to erect the entire project start to finish. And Anderson Brothers, which you'll see in the notes there, was the pool company. They were the one-stop shop. So they hired RWT, which you'll also see the design and the overviews and the layouts. The one image you saw before the hot tub and fire pit must have been a preliminary image, because the fire pit and the hot tub were included in the project, which I have documentation of, and which you'll also see that I provided when we petitioned, the setback. RWT did the design, and then Anderson Brothers carried it out. Distinctive Landscape was then brought on when the pool was done and the architecture was done to carry out the hardscape with the pavers, the retaining walls, the columns for the hot tub, and so on. We were under the impression that they were reputable, that they pulled permits, which they did for the pool, and it wasn't until the conclusion of the process that they came out for a final inspection of the pool and said, well, your hot tub and fire pit don't meet setbacks. And as homeowners, we were caught off guard. We had already paid for everything in full, minus like $3,000, which was basically the balance of a large project. And at that point, they refused to acknowledge or change anything because it was already done. The project was already done. They came out and said, oh, well, your setback's not there. And I have drawings and everything that we approved with RWT, with Anderson, that we thought were in the scope of the guidelines of Macomb Township. And again, upon completion, the city came out and said, it doesn't meet, there's no final approved. And at that point, we were at a standstill. We confronted Anderson Brothers about the whole project. They refused to do anything for us. We actually got an attorney involved and spent about $1,600 trying to get them to reconfigure the fire pit and hot tub. This is pre-COVID. And we had a meeting with them. They again refused. Then COVID hit, and we've never heard from anyone since. And now we're in a spot where we're moving, and we're supposed to close on our property in a month from now. Basically, just no end in sight. And we've tried getting other companies involved to maybe move everything 3 feet. The problem with that is when you knock down walls and it's all, you'll see symmetrical and all tied together, it's $30,000 to move everything 2.5, 3 feet. So basically, we're asking, again, the mercy of the township to understand that we didn't intentionally do anything wrong. We didn't construct it ourselves as homeowners. It was professionally paid for. They essentially dropped the ball on us and have disappeared since, especially given COVID in the middle of that. And we have no way to rectify it outside of spending $30,000 for, again, 2.5 to 3 feet. So we're hoping that, we're not infringing anyone's property. It's the hot tub, which is covered year round. It's not a pool, which is an open body of water. We're just hoping for some understanding that, again, it wasn't our intention. We didn't do it personally, and we're stuck essentially with where we're at.
All right, any questions for the applicant from the board?
I have one. Who was the original permit puller? Was it?
The Anderson Brothers supposedly pulled everything on behalf of everybody. That's what we were told. That's in their contract, that they were kind of going to be the one-stop shop to address all the issues.
So, Mr. Box, who is ultimately responsible at this point, 5 years later? Obviously, there's a mistake made. Anderson Brothers is a permit holder. Are they ultimately responsible, or is it just the homeowners at this point?
I would think in legal terms, the person who pulled the permit is responsible. If a permit were pulled and the final inspection approved, then it would revert back to the homeowners. But the fact that it was never approved, the final inspection, I would think, and Mr. Aloy can correct me if I'm wrong, I would think it would still be the contractor.
Yeah, the contractor remains responsible under the permit until it's resolved. But the homeowner is also responsible because it is his property. So ultimately, they both have a responsibility to deal with this. That's why the property owner has petitioned, because he owns the property. He has to deal with this nonconformity at this time. And as he said, he has to sell the property. And as it sits right now, it's what's called an illegal nonconforming use, which means that it does not meet the current ordinances. It is not legal. And so only a few things could occur. One, it's knocked down or moved, or can remain in place if there's a variance. Oftentimes that these are dealt with through the district court where there's violations that are issued, and that those misdemeanor tickets are issued to the contractor, potentially the homeowner, until such time that the issue is rectified.
So regardless, even though Anderson Brothers is ultimately responsible, it's the homeowner's fight to get to that point.
It's their property, right? So, I mean, the nonconformity is owned by the property owner at this time.
Thank you.
Any questions? Hearing none, I'm going to go out to the public. Is there anyone from the public who wishes to speak on this item tonight? If you wish to do so, please come forth to the podium, to the one over here. State your name and address for the record, and give any comments you might have. Hearing none, I'm going to close the public portion if there's no further comments, and bring it back to the board. Mr. Box, one question for you on that permit. You showed the original permit drawing that was pulled up, and I was looking down and looking back. I was just wondering if the hot tub had been. So the hot tub was not actually part of the original permit. It's not that it was moved or enlarged. It's an addition to. Is that
It appears that
accurate?
way, yeah.
In your packet, it states that the necessary permits were not obtained prior to the construction of these items.
Right, obviously, I'm just curious whether or not it was a permit where they installed it in a different location and did not complete it as per plan, or if it was just added to it. In this case, it's just simply not on the permit. And Mr. Loy, I think we may have had some discussion on this, but typically this board doesn't penalize someone for not building without a permit, but typically neither do we look at whether a structure is built as a reason for granting a variance, broadly speaking. Is that generally accurate?
Well, this board is not a penalizing board. You're not to administer penalties. Your job is to weigh whether or not a variance is appropriate under the standards. So the fact that this was built previously without the proper permits and exists today is something you can weigh under the factors that you're well aware of for a variance.
Very good. And then Mr. Box, again, something that I know you mentioned, but I was trying to get my internet working, so I had my agenda up here and may not have heard it all the way. You had referenced, I believe Mr. Van Tiffelen had some comments with regards to a swale. Could you just repeat that again?
Yeah,
And
in
give
your
us that
packet, you see the comments from the engineering department. They are recommending a 3.5-foot green space provided. So if you think of your yard, especially if you're in a property that was, a house that was built in the last 10 or 15 years, your elevation probably starts to slope down near your edge of your yard, as does your neighbors. That creates a swale, essentially, that allows drainage either to the front or to the back, depending on where you're at in the yard, where the crest is in the yard. It was his opinion that 3.5 foot of green space was the minimum needed for safe drainage of stormwater in a swale area.
Mm-hmm. And that's probably one of the reasons why we have these separated, the variance is separated,
Correct.
the request separated. Okay. I guess my only comment would be here that typically we don't look at too heavily at whether something is built. This is a slightly trapezoidal lot, and if I look at where the angles are, I would think that if the line was carried from the front area, it's possible that the hot tub might have been in compliance if it was a straight lot back. In other words, if it was not on a curved road, it's possible that that one might be within. I don't have a scale here. I'm not sure if I find that enough to be a practical difficulty, but I would certainly think that's somewhere in the neighborhood of what a practical difficulty would be. So, be my only comment, and I will bring it back to the board for any other discussion, comments, or motions.
Mr. Chairman, I have a question for council. If we were to approve this variance, are we setting a precedence for, in the future, contractors that get a permit and then do things that are not, they go outside the bounds of the permit? Are we setting a precedence for people to be coming in and then, it's just kind of an open-ended, the contractor did it, we have to approve it and let it go? you know, from kind of here on out, moving
Sure.
forward with other, you know, other
Sure.
residents.
That's always a consideration by this board, is setting improper precedents in other situations. Although in your packet, there are other reasons that you could find that there is a hardship. For instance, the 11-foot easement in the back, which creates a difficult building envelope for the structure, and the irregular shape of the yard. So if you were to find the necessity of the variance based on those factors, I don't believe that you would be, although it's already constructed, I don't believe you would be setting precedent, but rather looking at the unique shape and easement in the backyard. So, the circumstances are what they are. I don't know that other properties would have those same features in the backyard.
Okay, thank you.
Yes.
Any other comments from the board, questions? Mr. Box, anything else you'd like to mention before we go into a voting period here?
Nope.
All right. To the petitioner, I know I mentioned it earlier, we're at 3 members. Any motion needs 3 votes in affirmative to pass. Anything less than 3 votes, even if it's like 2 to 1 in affirmative, the motion fails because we need 3 votes. Are you comfortable moving forward? Would you like us to entertain a postponement to another meeting?
Yes, I'm comfortable.
Okay. All right, hearing that, I will bring it back to the board for any motions. And remember that this is technically 2 requests. We I think we probably should treat them separately as 2 different requests in front of us this evening.
Mr. Chairman, I can make a motion. Forgive me if I'm getting this wrong. It's regarding the variance under section 10.0311.e.f.3. And this is regards to the 7.5-foot required setback and moving I believe it's the hot tub to 5 feet. Based on our conversation here tonight, not taking into consideration the monetary aspect of it, but looking at the shape of the lot, the required easement in the back that you have obtained, that you are within, I'll make a motion to approve the variance.
Motion by Mr. DeCoster, is there support?
Support?
Support by Ms. Lawson, and we're gonna do a roll call on this one. Ms. Lawson, could you please call the roll?
Okay, Member DeCoster?
Yes.
Member Slauson, yes. Chairman Tuckfield?
Yes.
All right.
All right, so then we would look for a request or a motion on the second request?
Mr. Box, is it the same ordinance?
Same ordinance, well, no, it is not the same ordinance number, I don't believe, and I apologize, I don't have that in front of me. But it is the patio area or the patio / deck, however you want to refer to it, is a 7.5-foot setback requirement. I think it is actually a different number, and I don't have that in front of me. But I think we can,
Just to be clear, what is the required setback for the patio portion?
7.5 feet as well.
It is 7.5.
Yes.
It's the same, but with a 2.
With a 2 at the end, okay.
I think, do you mind if I interject? According to Mr. Joe Maples, if we're referring to the retaining wall, I think that was 3 or 3.5 feet.
Yeah, I
The
see
water's edge
3.5
was 7
feet.
and
Yeah.
7.5. The retaining wall, which is the fire pit area, was, I believe, around 3.
I believe, in the review, we do show this as 10.0311 EF2, which is what Melissa has in here, and she does say 2 feet where 7.5 is required, so I don't know if,
Yeah, the one that you have where Joe Maples signed it,
it also says 7.5.
he's the one that filled that out, so I would trust his.
Okay. Well, that being said, I'm gonna make a motion regarding variance or ordinance number 10.0311.e.f.2. And this is in regards to the patio setback requirement of 7.5 feet and allowing a variance of 2 feet. Same as the reasons I said before, not taking into consideration the monetary value and the permit issue, but the somewhat odd shape of the lot and the fact that the homeowner did stay within the rear easements, and it's kind of an odd-shaped area back there, very thin. I would make a motion to approve this variance.
Support?
Motion by Mr. DeCoster, support by Ms. Lawson. And Ms. Lawson, will you please call the roll?
Member DeCoster?
Yes.
Member Slauson, yes. Chairman Tuckfield?
Yes. That motion passes and that variance is approved. Thank you very much for coming in. Hope that all goes well for you.
Thank you.
That takes us on to item 9, which is public comments. Any member or any person in the audience can speak at this point. If you wish to speak, please come up to the podium and state your name and address for the record. Seeing none, I will move on to the next item, which is ZBA member comments. Ms. Lawson, Mr. Coster, anything for us this evening?
The only thing I have is a question, do you know if we're scheduled to have an October meeting?
Yes, you will.
All right, very good. I don't have any comments here this evening. Actually, yeah, I don't have any comments. I think I had something I was going to say for planning, but I didn't write it down, and it's not in my head, so I will leave it for another time. Number 11 is planning director comments. Mr. Box, anything for us this evening?
I just wanted to point out, Mr. Tuckfield, I know we talked about it a little bit earlier, but the master plan, we're gonna have an open house, September 23rd. It's, again, open house style, so just kind of come in at your leisure, 4 p.m. to 8 p.m. It'll be at the rec center upstairs in one of the auxiliary rooms or multipurpose rooms. And I hope everyone can attend.
Very good. Thank you, Mr. Box. Mr. Loya, I know we don't have a line here for you, but anything you'd like to comment on this evening?
Nothing, thank you.
All right, thank you, Mr. Loya. With that, I will move us on to item 12, which is adjournment. Any motions?
Adjourn.
Ms. Lawson, a motion by Ms. Lawson, is there support?
I'll support.
Thank you, Mr. DeCoster. Motion by Ms. Lawson, support by Mr. DeCoster. All those in favor, please signify by saying aye. Aye. All those opposed by saying nay. Then at 6:56, we stand adjourned.